My name is Cumbrai, and I'm part of the team here at Oxford Professional Education. Just a bit of housekeeping. I'd like to mention that this webinar is being recorded. And today we've got a webinar by Robyn, of course. And they'll be covering, is it time to take AI to court? Really interesting topic. So Robyn, I'll hand over to you now.
Thank you very much. Yes, today is a fun topic, and I need you to be my jury today. So I will be asking your ideas and your thoughts on some cases that have gone to court regarding AI. So I want you to picture that kind of feeling throughout this whole session. So we're in a courtroom, okay? And there's a judge and there's a jury, and today you guys are my jury. And those who watch back, you can join in. I just sadly can't give you the feedback from your kind of responses. But what I want you to think about, let's be a little bit more specific, okay? So instead of just thinking about a courtroom, I want you to put yourself in the shoes of some of these people who have gone to court. So imagine it's 11 p.m. and you're a marketer and you're just hitting publish on a client's blog post that you have used AI to draft an hour earlier. It could be you're a customer typing a question into a chatbot and you're trusting the answer that comes back. You could be a professional that is exhausted, letting a research tool handle the last bit of your workload at 9 a.m. All of these very small, very ordinary moments are having a huge impact when it comes to who is responsible for the use of AI and the mistakes that AI makes. And when we're doing this, when we're looking at these things and going, yes, we can get that done. Yes, ChatGPT can do that for us. Claude can take that over. We're not thinking of the risks in these small, tiny moments. So what happens then when the AI is wrong? Not maliciously, just wrong. Wrong confidently, wrong fluently. And suddenly, everyone in the room, the marketer, the customer, the professional, the company's own legal team, is looking around and asking the same question. Whose fault is that? And that's what I'm going to put to you and my jury, which I've all forced you to take that role today. I'm going to ask you, how do we decide who is at fault when it comes to AI mistakes and impacts of AI mistakes? So when an AI system produces something that's harmful, misleading, or biased, realistically, somebody or something has to answer for it. But the question we're going to kind of spend the next kind of 40 minutes, 45 minutes looking at is who? Yeah. So who is really responsible when AI gets it wrong? That's what we're going to be covering today. So we're going to look at 4 pillars of blame or 4 pillars of responsibility if we want to be slightly more optimistic when we're looking at kind of AI use. Is it the company that built the model? Within that company, is it the developer who created that process? Is it the organization that deployed it? Or is it the person who typed the prompt and hit publish? Yeah. And also, is it the system itself? Because that is being taken more and more seriously. And some very, very expensive lawyers have already tried to take a system to court and blame a system. I'm going to kind of give you the full reality of this session, though. I'm not going to tell you the answer, realistically, because nobody agrees on this yet. And that's the problem. Regulators don't agree. courts in different countries are reaching different conclusions on identical facts, even inside the same company, legal and marketing often cannot agree on where their own exposure sits within these kind of problems. And this isn't a kind of future problem anymore. It's not hypothetical. It's already happening in tribunal rulings, in how vendor contracts are being written and getting rewritten. Has anybody just clicked yes on their terms and conditions recently on ChatGPT and Claude? It might be worth going to see what you have agreed to. It's happening in legal kind of headlines, and all these kind of question marks are all over our kind of work at the moment. But what I'm going to show you and talk you through is how it's starting to play out, because the problems that have happened have now gone through full court cases that I can talk you through. Whereas before, when we first started doing kind of OxPE AI Exchange, some of these court cases hadn't happened, or they were still in ruling, so we couldn't really give a conclusion, right? There was nothing for us to base what we need to do on the things that have happened. So let's talk today about kind of real cases, real consequences. And I'm also going to give you a way to reason through it, because that's what we're missing. We're missing that framework. And I've put it in this fun, I think it's fun, and I hope you all agree fun, kind of court kind of layout, because if I gave you a straight talk on AI liability, I don't think many of you would have shown up today. And what I want to do is talk you through and also allow you to force yourself to make a decision, because you may be in a situation where you have to decide whose responsibility X, Y, or Z is. And every case that we look at today will kind of end with us voting or us talking, and then I'll talk you through the guilty or not kind of verdict. And that vote, where you sit on that line, will also show you things like your comfort level with AI, your understanding of this technology, and your fear of this technology, which I think is also wonderfully important for you to recognize. Yeah. And I want you to take away, there's 3 cases that we're going to go through today, and I want you to take away kind of what you think and how they made you feel, and where you as an organization, a professional, an individual who uses AI, where do you sit on that blame kind of spectrum? So we're kind of going to focus on understanding the kind of current legal and regulatory kind of landscape around AI accountability, because I'm going to ground it in some kind of real cases for you. We're going to look at a working framework. So we're looking at developer, organization, individual, and the system itself, and how you can reason through those different areas of responsibility. I'm going to give you a practical method for allocating and documenting responsibility before something goes wrong, not after, like these poor individuals in these kind of cases we're going to go through today. And also, I'm going to give you language that you can use internally with yourselves, your teams, your clients, leadership, and kind of start to understand when AI use needs policy. Yeah. So we are now in our courtroom. We are ready, and I want to kind of introduce our 4 defendants. Yeah. So when something goes wrong within an AI system, there are usually only 4 places that you can point. Yeah. And these are our defendants, because we're going to be cross-examining them all throughout these cases today. So first up, we have our developer. Now, that is the broad term when you look through these kind of cases that is used to describe the company that built and trained the model, the one that decided what data it learned from, what guardrails it had, and what warnings, if any, come attached. So if you think of the developer as OpenAI, Google, Anthropic, or the smaller vendors behind niche AI tools, that is who we're talking about here. And their defense, often, when it comes, almost always sounds the same. We shipped a general purpose tool, not a promise about a specific output. They cannot predict every way a customer might use it. So you need to remember that. That's our our first piece of evidence. Yeah. So from a developer's point of view, they cannot predict every way a customer might use it. So secondarily, we're going to look at the organization. So this is the business that took the tool and put it to work, licensed it, and integrated it into things like a website, a hiring pipeline, a customer service line, and put it in front of real people under their own name. So this is a company such as a airplane company putting a chatbot on their booking page. It's your own agency's clients running AI drafted content under their brand. Now, their defense that we need to remember, we didn't build the flaw. We just used the product the way it was sold to us. So the organization's defense is that they didn't build the flaw. We just used the product the way it was sold to us. Yeah. Then we have the individual. That's you and me. Yeah. This is the person who actually did the thing. We wrote the prompt. We reviewed the draft and then we hit send. Yeah. So this is a marketer publishing AI assisted copy. It is a lawyer filing an AI drafted brief, a HR manager accepting an AI hiring recommendation without a second look. Their defense is the most human. I was doing my job with the tools I was given, and I trusted them to work. And the fourth is the system itself. This is the one that sounds almost like science fiction. Yeah, until you realize how often it gets argued in real courtrooms, sometimes sincerely, sometimes as a smokescreen or a cop-out for the other three. Should the AI bear some responsibility as an entity in its own right, separate from the people and the companies behind it? Today, almost every legal system on earth says no, because AI has no legal personhood. It cannot be sued, it cannot be fined, it cannot be held liable for anything. Which means that whenever someone points at the AI, the system, what they're really doing, whether they really kind of realize it or not, is trying to point away from themselves. So when I go through these next three cases, I want you to keep those four in your head. Yeah? Developer, organization, individual, or the system. Every case that we look at today, we're going to be asking the same two questions. Who is really on the hook here? And does the law, when we find out what actually happened, agree with your gut? Yeah? Sometimes it will, sometimes it's going to surprise you. And the gap between instinct and outcome is why we're doing this session. Yeah? So does anybody have an idea who is generally wrong or who generally ends up taking the blame when AI goes wrong? Oh, I have a private message. Okay, that's interesting. You think it should rely more on the developer and how the organization sits, but you feel that it comes all the way down to the individual. Yeah. Has anyone ever blamed the system? Well, it was the AI. It was ChatGPT. ChatGPT gave me that answer. I bet we all have. Maybe in the earlier days. Yeah. So I want you to kind of think about that answer. And we're going to come back to it at the end because your feelings may have changed. I'm not trying to give you kind of like a 360 or a 180 or whatever on AI use, but I want you to start really thinking about it. So how does the courtroom work? I will run through the case, I will present you the facts, and then I will walk you through the argument for and against, and then I'll give you a moment, and then I want you to vote. I want you to let me know. Yeah? So each case, 2 cases are real. The third one is what is happening a lot online, but hasn't quite made it into the courtroom yet. It's the next manner of behavior that will be kind of brought into courtrooms. If you look at kind of the behavior and the way that AI use is kind of trickling into our legal systems. So the first case is real. It's something that we've probably all kind of done. And it actually cost somebody real money. So that's why it ended up in court. So this is the case between Moffat and Air Canada. Yeah, so it concluded in 2024. So let's set the scene. In November 2022, Jake Moffat's grandmother sadly died. And he needed to get from Vancouver to Toronto fast. Yeah, he needed to get there to attend the funeral. Like most of us would, he went to the airline's website to sort out a flight under time pressure and grief. Not exactly the moment that you want to be reading fine print. Yeah, he's there trying quickly to get the chatbot to tell him the best ways to do things. He used Air Canada's website chatbot to ask about bereavement fares, which are the discounted rate airlines offer when you're traveling because of a death in the family. The chatbot responded something incredibly specific. He could book his flight at full price now and then apply for the bereavement discount afterward by submitting a refund application within 90 days of the date that the ticket was issued. That was not vague. It was specific. It had specific numbers, a specific process, and it was delivered with total confidence. So what did Jake do? Jake booked it. Yeah. He booked the flights, he flew to Toronto, he attended his grandmother's funeral, and then he came home. Then he submitted his refund application within the window the chatbot gave him. Air Canada said no. But here's the twist that makes this kind of case really interesting and one of the first of its kind. Buried elsewhere on Air Canada's own website was a separate page titled Bereavement Travel, which said the discount could not be claimed retroactively only before you travel. The chatbot had, in effect, contradicted the airline's own published policy on the airline's own website. In the same conversation where it was supposedly helping a grieving customer get things right. When Jake pushed back, Air Canada actually admitted before this ever reached tribunal that the chatbot had given him misleading words. That's what they said. That was their own language. But admitting the bot was wrong and admitting they owed him money turned out to be 2 very different conversations. So he took it to tribunal. In front of the tribunal, Air Canada argued that the chatbot should be considered, in effect, a separate entity, and that this somehow absolved the airline of responsibility for what it told customers. In essence, don't blame us, blame the bot. Yeah? And the tribunal member, Christopher Rivers, wasn't having it. Yeah. He pointed out that Air Canada never explained why a customer should have to double check what its own chatbots told them, or why one part of Air Canada's site should be trusted less than the other. So there's our story. There's our information for case one. Yeah. So in that, if we kind of go back to our like little thing here, the organization blames the system. That's what they went, their route that they went down. Yeah. The organization who had created the chatbot and launched the chatbot blamed the system itself. Who do you think was guilty? Who is actually on trial? Is it the organization for what its own chatbot promised a grieving customer? Or is there something to Air Canada's argument that the AI, in some meaningful sense, acted on its own? What do you think? If you don't want to pop it in the general chat, you can just message it to me if you would prefer.
I would think maybe the organization, because surely there's some testing that you do before you publicly put it on your site and also on like your verified site. So if someone does sort of, if it was like maybe let's say like a duplicate or dupe site, perhaps it's something else, but because it was so official and everything was official, it seems unfair that anyone else should
Well,
take the blame.
I think you would have been wonderful on the jury for this one, to be
Oh,
fair.
thank you.
So they basically, there's kind of two kind of main things, was that the organization is liable or the organization wasn't. That's what it boiled down to. Yeah, it's not like we could take the system to court instead of Air Canada. So the kind of two sides were that Air Canada built and published the chatbot on its own site under its own brands. So why would customers have to doubt that? The tribunal was very blunt. A company is responsible for all information on its website, static page, or chatbot. There's no distinction. Air Canada had the ability to test and correct the bot before launch and to fix it once the error was known. That is what is called control. Yeah. Air Canada argued quite meekly, I would say, in the grand scheme, that the chatbot is a distinct AI product and shouldn't be treated like a human employee or a static web page. Some organizations argue disclaimers, things like this bot may make mistakes, should shift responsibility onto the user who relied on it. So do you think that Air Canada were found to be guilty or not guilty? What do you think? They were found guilty. Yeah. So the tribunal rejected Air Canada's argument outright. In the written decision, the tribunal member put it plainly: the airline owed Moffat a duty of care simply by virtue of being a service provider dealing with a consumer. It's as simple as that. Yeah. And it failed that duty. It failed that duty by not taking reasonable care to ensure its chatbot's answers were accurate. So the ruling found that Air Canada was liable for negligent misrepresentation, full stop, no carve out for the fact that a bot said it rather than a human. Now, how much do you think this was all over? $650.88. And that was the exact difference between what he paid and what the bereavement fare would have cost him, plus interest and his tribunal fees. Can you imagine how much Air Canada paid their lawyers to try to argue this out of court? I'm sure it was much more than $650. Yeah. So did your kind of gut match that ruling? Yeah. Yeah, most of us recognize that in reality, the organization has the responsibility to understand. But realistically, as an organization, would you not try to protect yourself in this instance? If you can point blame and shift responsibility, that is something that happens too. So that I want to be direct about kind of that this isn't about airlines. Yeah, this is just one organization. Air Canada is a convenient, it's slightly absurd example of a company arguing its own customer service tool is a legal stranger to it. But strip away the airline branding, and what's left is a pattern that applies to almost every organization. Any business putting an AI tool in front of customers, a chatbot answering questions, an AI generated FAQ, an automated quote or pricing tool, a virtual assistant on a booking page is making the exact same level of risk as Air Canada made. And the tribunal's reasoning tells you exactly how that will be evaluated. Not by whether you disclosed the tool was AI, not by whether the answer came from a static page or a live chat window, but by whether a reasonable customer was entitled to trust what your brand told them through the AI system or not through the AI system. So if your organization or your business is relying on a line buried in some kind of terms and conditions that says this chatbot may make mistakes, read this case twice, because that's exactly the shape of the defense that failed. That isn't enough. A disclaimer nobody sees doesn't discharge a duty of care when it comes to AI use. If your AI tool wears your logo, sits on your domain, speaks in your voice, tribunals and legal entities are treating that as your voice, full stop. There's no asterisk for but a machine said it. Yeah? So that is case one, and the verdict is guilty. So when we look back at our four defendants, they didn't blame an individual. So they weren't blaming Jake in this. They could have gone down the thing that he should have verified it, and that would have been their whole thing, but they didn't, because it wasn't strong enough. They weren't blaming themselves. What they were doing instead was blaming the system. The system made a mistake, and the system caused a problem. Yeah. So let's have a look at case two. So case two moves us from the organization to an individual. Yeah. So this one involves two lawyers, a personal injury claim, and what happened? Yeah. So this is Mata versus Bianca. Yeah. This case was it's very ordinary. Yeah. It was a very ordinary lawsuit. So Roberto Mata was flying Ivanka from El Salvador to New York when he claimed a metal serving cart struck his knee during the flight. Very, very straightforward personal injury claim. Yeah. The airline moved to have it dismissed, and Mata's lawyer needed to file a response defending why the case should go forward. So that's our kind of beginning of this case, why we ended up here. That lawyer was somebody called Stephen Schwartz, who'd practiced law for over 30 years, but had never actually used ChatGPT before. By his own account, he treated it like a supercharged search engine, one that can point him to precedent supporting his argument. He asked it for cases, and it gave him six with names that sounded exactly like real aviation litigation. Varghese versus China South Airlines, Martinez versus Delta Airlines, Shaboon versus Egypt Air, and all of these kind of things that he got back And each one came with a docket number, a court, a date, and quoted passages that read like genuine kind of legal reasonings. The lawyer, Schwartz, didn't verify it against any kind of actual legal databases. And his colleague, Loduca, filed the brief without reading it either. What they discovered was that none of these 6 cases existed, not one. So the kind of airline's lawyers ran routine citation checks, the kind that any opposing counsel does, and came up empty on every single one, every single piece of evidence that this lawyer had brought forward into this defense. And they flagged it to the judge and asked the plaintiff's team to produce the actual case text. But here's where it gets worse. It doesn't get better from here. Yeah? Instead of admitting the mistake, Schwartz went back to ChatGPT and asked it directly whether the cases were real. ChatGPT said yes. He asked it to produce the full text of one of them, and it generated a completely fabricated opinion, confidently, in the exact format of a real decision, and he submitted that to the court too. When challenged, Judge Castle didn't rule that the technology was on trial. He held a sanctions hearing and found that both lawyers had acted in what the court called subjective bad faith. Yeah? And they were fined. Their firm was fined $5,000 each. He also ordered them to write personally to every real judge whose name had been attached to one of the fabricated opinions explaining what happened. So who's on trial now? The lawyer who filed it, who had every professional tool available to verify all of the citations and didn't use any of them? Or is there a case that the developer bears some responsibility to for a tool that fabricates entire legal opinions with total unhedged confidence and gave a 30-year veteran attorney no signal whatsoever that anything was wrong? Who's on trial here? Okay. So the lawyer definitely wasn't worth paying. I do agree with that message that I just received. But in reality, the poor person who was doing the normal kind of personal injury kind of lawsuit, Robyn MacMillan, he was paying a lawyer to do a lawyer's job. The lawyer chose to rely on AI. AI fabricated a response, which then impacted the trial, right? So where do we go from here? What happens next in this kind of process, in this world? So we have our fors and against. So is the individual liable? So lawyers carry a professional duty of candor to the court. That duty doesn't disappear because a tool did the drafting or the research. Oh, we've got another one here. The lawyers, they have a responsibility and a duty not to mislead a court, so the emphasis on them to produce, yeah, absolutely. They didn't fail to check just once. When challenged, they asked the same unreliable tool to verify itself and accepted that too. The court's own opinion was blunt. Technology can assist, but cannot replace the judgment and diligence that profession requires. So then we look at our against. So this tool gave no clear warning that outputs could be entirely fabricated with total fluidity, arguably a developer disclosure failure. Okay, maybe. Non-technical professionals were using these tools without training. Yeah. If the firm had no policy on AI use in legal research, is that a governance gap or a judgment gap? So do we think this was squarely the lawyer's failure, Or does responsibility spread further up the chain? Or as we kind of have our wonderful kind of 4 defendants, does it actually start right back down here? So they were found guilty. Yeah. And the poor guy who did have his knee struck by the thing had no leg to stand on at this point. Pardon the pun. But let's be precise about what actually happened, because this matters. Judge Castell sanctioned the joint, their firm jointly. OpenAI, the company that built the tool, was found to have no sanction, no fine, no finding of liability at all. The court's focus stayed entirely on the humans who filed the brief. Yeah. So it's quite tempting to be like, okay, ChatGPT lied. ChatGPT did this. But actually, the ruling says a licensed professional had a duty to verify what he filed under his own name, and he didn't. And when he was given a second chance to catch it, he asked the same unreliable tool to grade its own homework and believe the answer. Yeah? The technology's failure was real here, but the court's judgment was aimed entirely at the human judgment that should have caught it and didn't. Yeah? Now, I want you to sit for a second and swap legal brief for client proposal, where you fabricated by accident a case study statistic in it. Swap it for ad copy that cites a clinical result that doesn't exist, or a LinkedIn post attributing a quote to someone who never said it. The pattern underneath is identical in every version. A tool that generates something fluent, specific, and confident sounding, and a professional under deadline pressure who publishes it without checking. Yeah? Schwartz wasn't reckless in some obvious or cartoonish kind of way. He was busy, like we all are, and he trusted a tool that was being written up everywhere as a breakthrough, and he didn't check. So that's an actual lesson to take away. Verification isn't a nice to have anymore. It's not something you do when there's time. It's now a core part of the job description. So case three is invented, but it's drawn from things that we do every single day. So it's built the way it is because every element in it is lifted from patterns already showing up in marketing, communication, and teams right now. I've just put it under Northfield Health. Yeah. So this is a mid-sized wellness brand that sells a supplement line online. Like a lot of tiny little marketing teams, they've adopted an AI content platform to keep up with the volume their competitors are producing. One of these pieces falls to a freelance marketer brought on for exactly this kind of output, paid by the piece, not by the hour. She's told to create a blog post about Northfield's newest supplement, something that reads authoritative and gives people a reason to buy. She prompts the AI tool for a post highlighting the product's benefits. The tool generates clean, confident copy and drops in one line that reads like every other wellness article on the internet. A clinical study found the product improved energy levels in 87% of users. A specific number, a specific claim, exactly the kind of detail that makes marketing feel credible instead of generic. There is no such study. Yeah. The AI invented the number the same way it might invent a court case or a bereavement policy. We all know, and I talk about this all the time, that AI is optimized to produce plausible, well-formed text, not to distinguish between a fact it knows and a fact that merely sounds like something it should know. So the marketer moving fast doesn't check it. It reads like every other blog. Nothing about it, gets a red flag. It goes to an internal reviewer. Nothing really happens. They don't check all of the factual sources. The reviewer approves it. It goes live as a blog post, and then because it's performed well, goes then into pulled into paid ad copy, and is now running in front of thousands of people with a specific false statistic underneath the brand's name. A competitor's marketing team spots it. Maybe they're doing routine kind of research. Maybe someone just recognized a suspiciously formula kind of wording. They report it to advertising standards, and the regulator opens a formal investigation into Northfield for misleading health advertising. Now Northfield has to explain to a regulator, to their own legal team, and possibly to the press exactly how a fabricated clinical statistic ended up in paid advertisement carrying their name. Realistically, every defendant has a case against them. Yeah? This is not as cut and dry as the other two cases. Every single group has a case against them in the case of Northfield versus whoever. Yeah. And this is the scenario that we're mostly one deadline away from. Yeah. This is not because anyone is careless, but because the conditions that produced it are completely ordinary. A freelancer juggling multiple clients who's paid for output, not for hours, a content platform that's very good at sounding authoritative, a review process that, if we're honest, was probably designed back when the biggest risk in a blog post was an off-brand tone, not a fabricated statistic. None of this is particularly kind of odd. Yeah. Most of this is probably in some of our pipelines that are running our businesses right now. And nobody in the Northfield story set out to publish a lie. Every single person in that chain made a decision that felt reasonable at that time, given what they knew, what they were being asked to deliver, and how much time they had to deliver it. And that's precisely why who's responsible can't be answered with a single name pointing at a single kind of villain in this kind of story. And realistically, we've put 4 defendants on trial across kind of 3 cases. And if you're feeling like the answer isn't very solid, that's accurate. Yeah. There is no single answer. Responsibility isn't a fixed point. And where you land on that kind of spectrum depends on a number of different factors. The one thing that you need to think about, though, are these 4 areas. Control. Who had the power to prevent or catch this? Foreseeability. Was this a known risk? Verification. Did anyone check it before it went public? And disclosure. Was AI involvement made clear, or was it buried in terms and conditions? So I want you to kind of stop asking who's responsible if it goes wrong, because realistically, as you've seen, there's multiple ways you could point that blame against that responsibility pillars. But what we can do is ask exactly who verifies this before it reaches a customer, and what is that process? And then we need to actually write it down. Yeah. I mean, like, literally, get some paper, a document, write it down, because an answer that lives in someone's head isn't a policy, it's a habit. And it's a habit that only survives exactly as long as that person stays in that role. And the organizations that are not ending up in these kind of liable situations are the ones with a written answer that's ready, not the ones improvising a policy in real time. I don't want you to think that I'm telling you to not use AI. None of this is about slowing AI adoption down. But every case that we've looked at today involved organizations and individuals who are doing something completely reasonable using tools that genuinely save time and genuinely produce good work most of the time. But it's about the organization that when someone finally asks the question, a customer, a regulator, a journalist, a judge can answer clearly and immediately whose responsibility this was. Yeah. So I don't want you to find out the hard way in a tribunal ruling that it was actually down to you. You should know what your responsibility is. So that's the case rested for today. We're not going to do any more cases. But what I want to give you at the end of this slide is a little reference card that you can kind of utilize. So when we look at the developer kind of responsibility, who has the power to prevent this? Where does control sit? Within an organization, what is the foreseeability? What is the known risk of this? When it comes to the individual, who verifies? Did anyone check before it went public? And then we have the system. Yeah. So what is the disclosure process? And where was AI kind of highlighted? So that's just a reference that you can kind of take out of these slides and kind of share internally, or when you're looking at developing or creating your own AI kind of policy documents. But we have something pretty exciting. We are moving our community over to WhatsApp, supported by the glorious kind of OxPE AI Exchange team. So if you want to give this a scan, you can join our WhatsApp. And in there, there's going to be general chat. We're going to be sharing AI chat and discoveries. If you've got any questions after the webinar that kind of arise, you can pop them in the webinar Q&A. And then me or one of the other kind of individuals will be able to populate those kind of channels for you. So I would love you all to join that WhatsApp channel, and then you can kind of stay up to date and stay connected to all of our other individuals. We are moving away from Slack. So if you're currently in our Slack, you will get a message soon to invite you to here, but you can join early if you're already in the room today. So does anyone have any questions? My phone is starting to ping. So I assume that that's WhatsApp. Yeah, it is. Well, thank you. Thank you all for sharing kind of your time with me today. If you've got no questions, I will pass it over to Comprai.
Perfect. Thanks, Robin. That was really interesting. And I always find it quite interesting, actually, again, to just sort of look at the implications of
Yeah.
these things when
It's all
they
well and
go
good
bad.
to look at kind of like the great technology and learn how to do something new, but
Mm,
it's wild that we aren't considering the impacts of that and the jurisdiction of some of the things that we do. So yeah, it's good to
exactly.
see how small things can become big realistically.
Yeah, no, for sure. Um, but yeah, well, thank you again, everyone, for joining. And we'll send out the presentation in the next couple of days. If anyone does have any questions, then please feel free to, of course, pop them onto the WhatsApp chat, as Robin had mentioned. But then I think that's everything for today. Thank you so much for joining. We really hope you enjoyed it, and we hope you found it interesting. And hopefully we'll hear from some of you soon.
Yeah, see you
Yeah.
in 2 weeks' time.
See you in 2 weeks. I always, yeah, see you in 2 weeks' time. Bye,
See you.
guys.
Bye.